Did you just say ready, Freddie, right
I
before we
did.
started this? Yeah. Do you ever think about the stuff that how we're sort of lucky and unique in this country to be able to speak our minds because you can see it's not the case in other countries. Sometimes it's not even the case here. You ever think about that?
I do. That's funny you say that, and it's funny we're doing this podcast on this subject today because I thought about that this morning. Actually, I was watching Fox, and they had some writer for I'm not sure what publication, but was Russian, and he was going off about Putin, and I was just thinking to myself, there's no way he could do this in Russia. Like we
Well,
are
no.
so blessed to live in a country where we can go on and on about Biden as much as we want. Hopefully, I don't know about
Mhm.
online, but in person, at least for now, we can.
Yeah, I mean, we've seen just in the last week what happens to people who challenge Putin, obviously.
Yeah.
But this is going to be a really good episode to talk about all the stuff that is just like that, First Amendment protections and everything that relates to it, because this is the Line Drive podcast. I want to bring in our guest for this episode. This is a really good get, and I'm very pleased to have him here. I've been knowing about this guy and his work for, I'm sorry to say, I don't want to age either one of us, but about 2 decades. Professor Eugene Volokh of the Volokh Conspiracy, UCLA Law School, a really fantastic First Amendment legal scholar and expert. And Professor Volokh, thank you so much for spending some time with us today.
Thanks very much for having me. Always a pleasure to talk about free speech.
You have been in the news. The reason why I wanted to have you on, and one of my clients in my public affairs practice is Rumble, and you are involved in a court case right now. You might as well get right to it. You're the plaintiff, one of the plaintiffs. I guess you would, or are you the lead plaintiff? Is that accurate?
I am the lead plaintiff.
Lead plaintiff in a lawsuit against the state of New York. And actually, by name, you sue Letitia James in her official capacity as the Attorney General of New York and one who has to enforce and defend the laws of New York. Tell us, this is a First Amendment case that you have brought against the state of New York. You won the first round and got an injunction against the New York state law. And we just had on Friday of last week oral arguments in the Second Circuit Court of Appeals. As they appeal the lower court's ruling. Tell us, first of all, the New York law that it is at issue, so much so that you had to sue the state of New York over it. What does the law say, and what is so objectionable?
Well, so the law covers social media networks, which is defined broadly enough to include a blog that has a comment section. And it says that social media networks shall provide and maintain a mechanism for users to report incidents of hateful conduct. And hateful conduct simply means speech that, among other things, vilifies or humiliates people based on race, color, religion, sexual orientation, gender identity, and the like. And we don't have any policy that's specially targeted to hateful conduct. We don't have any mechanism for people to report that. I mean, to be sure, people can email me and say, I don't like stuff that you've posted. And most of the time I say, well, okay, good for you. So I didn't want to have any obligation to have a mechanism for reporting this incidence of basically these viewpoints that the New York government disapproves of. On top of that, the policy that we're supposed to have, in addition to the mechanism for reporting, has to provide how we will respond and address the reports of incidents of hateful conduct on the platform. And that makes it sound to me like we actually have to respond. And sometimes I may not want to respond. Somebody gives me some silly theory about how some post or some comment in his view is hateful. I don't care. I usually respond to people, but if somebody is annoying enough, I'm not going to. And I feel I have the right not to respond to people making such complaints. Now, one thing I should stress is the law does not say I have to ban comments, supposedly hateful comments, from my blog. I don't want to overstate the degree to which the law actually suppresses speech. I think the New York government would like laws like this to pressure platforms into removing supposedly hateful speech, but it doesn't actually require it. So we've got to acknowledge it's not as broad a restriction as it might be. But to the extent that it compels us to have a mechanism for reporting such speech in a viewpoint-based way. Remember, it doesn't just say you have to announce all your policies and have a mechanism for people to complain about whatever they want to complain about. It's just targeted to these particular viewpoints. That, I think, makes it unconstitutional, even if it doesn't outright ban comments like that.
I saw one of a quote of yours regarding this law and it was something like the state of New York has effectively tried to slap a law enforcement or a hate speech enforcement badge on your chest and effectively deputized you in their war against the freedom of speech. Is that an accurate way to put it?
Well,
that they're trying to enlist private citizens to do the suppressing?
Right. It's not just that they've deputized me in the sense of allowed me to restrict speech. On my blog, I can block comments, and sometimes I do, generally not based on their viewpoints, even when they're hateful, but, sometimes if they're particularly vulgar or personally insulting or whatever else. But rather, it's essentially enlisting me as its agent. It's like telling us, look, us being social media platforms, you need to have these kinds of policies. It hasn't gone so far as to say you need to enforce those policies, but you need to have these policies. You need to have these reporting mechanisms. And I think it is the first step towards a broader attempt to try to censor viewpoints that the government doesn't approve of.
Yeah, wow, that's amazing. So how's it going with the lawsuit? What are the next steps? How, what can you tell us about it?
Well, so far so good. My lawyers at the Foundation for Individual Rights and Expression won, as you point out, the case in district court. The judge, I think, quite correctly held that the law violates the First Amendment. There was oral argument in the case just last week, indeed, before the Second Circuit. Presumably, that's the federal appellate court in charge of, among other states, New York. Presumably within a few months or several months, let's say, the court will issue a decision. I think it'll be in our favor. Then New York could ask the whole Second Circuit to rehear the case, what lawyers call en banc rehearing. Right now it's just heard by 3 judges from the Second Circuit, because that's the way federal appellate courts usually work, with 3-judge panels. They could ask the whole Second Circuit to rehear it. And then if they don't get that, or if they lose before the en banc panel, then they can go to the U.S. Supreme Court. Now, I think it's pretty unlikely the U.S. Supreme Court will agree to hear the case, but it's possible. I expect what will happen is we'll win in front of the Second Circuit, and New York will see the writing on the wall.
Right.
Go ahead, Sonia. I'm sorry.
I was just going to say this issue is a little bit close to me because I used to work for a social media platform called Getter. I don't know if you've heard of it, but it launched as an alternative to Twitter back when Twitter was really suppressing speech, with Hunter Biden's laptop, back when Jack was the CEO and they didn't allow any speech that they disagreed with to be on the platform. But when I worked at Getter, it launched as an alternative to Twitter. And we ran into a lot of things like that, with really being surprised how strict the laws are in certain states, and definitely in other countries. Being able to operate in other countries, the laws were extremely strict on what you could allow and what you could not allow. So
that's fair enough. The First Amendment is very important, but it is applicable to less than 5% of the world's population.
Right.
True enough, but don't you? Yeah, I think a point is made in this case, though, that it's while this is a New York State law, because the internet doesn't really know any borders, it effectively it imposes this law basically on everybody, does it not? You don't have to be physically located in New York for this law to apply to you. Is that
yeah,
true?
I think that's right. I think the law would apply to us because we have users in New York. We also have a couple of our bloggers in New York. So yes, this is one feature of state laws, is that state laws that apply to the internet, is that they could cover conduct even in other states because it's accessible in that state. That raises interesting and complicated questions under legal rules such as choice of law, such as the Dormant Commerce Clause, and various others.
Yeah, I mean, the internet has really changed a lot of legal questions all the way around. So if you are predicting, and I'm sure you go at this having watched a lot of court proceedings and learned it in the law. If you think that you're going to prevail, you in the Second Circuit, and then maybe en banc, and then you think New York would just give up the game because they'll see the writing on the wall. You must feel that the oral arguments went pretty well on Friday of last week. Usually, sometimes you can get an idea of where the court is headed, but you feel like the oral arguments were definitely looked like it was in your favor.
Yeah. I think the oral arguments went well, but beyond that, I think we just have a very strong case on the law.
And I mean, you would know. I think, Sonny, before we go any further, I do want to run down a little bit of the Professor Volok's resume here. He's teaches First Amendment law. This is from your bio, by the way, on the Volok conspiracy, which you now it resides at Reason, right? You work in conjunction with Reason on this while maintaining editorial independence. Is that a good way to describe it? So I've known about the Volok conspiracy, this blog, Sonny, for probably nearly as long as you've been alive, I'm sorry to say. But in the meantime, Professor Volok teaches First Amendment law, an intensive editing workshop, a First Amendment amicus brief clinic, and business tort law, all at the UCLA School of Law, where he has also often taught copyright law, criminal law, tort law, and a seminar on firearms regulatory policy. You also clerked for Justice Sandra Day O'Connor on the U.S. Supreme Court and for Judge Alex Kozinski on the Ninth Circuit Court of Appeals. So I think, when the guy comes out with an opinion on the law, folks ought to take a listen. Have you been a plaintiff in cases before? You talk a lot and teach a lot about the law, but have you been involved in cases directly before?
Yes, but usually very limited cases having to do with the issue of access to court records. I have sometimes gone to court representing myself, just trying to get various records unsealed, and sometimes it has actually gone out to courts of appeals, where sometimes I've argued on my own behalf, but sometimes one advantage of representing yourself when you're a law professor is that then if you go up on appeal, you can split time with your student who helped you on the briefs, and give the student an opportunity or oral argument, which is very rare for students. It helps that in this case, the client is me, so I can say, I promise not to sue myself for malpractice if my student.
Were you sure about that?
So as Tim has mentioned, you've been doing this a while. You've had your blog going on for a while. So I wanted to ask you how you have seen things change over the years. The attacks that we've seen on the First Amendment, have they been ramping up like never before, or do you think this has just been a slow, gradual process?
Well, so I do think that there is more intolerance of speech now than there was when I was starting, say, in the mid-1990s, especially on university campuses. There used to be, campuses were always on the left, or at least as long as I've been around them. But it used to be that there was a mainstream center-left position that basically student speech and faculty speech needed to be protected. And if it's offensive to people, well, that's just the nature of speech. Could be a good opportunity to have lively debates. And then, hard to note, starting 10, 15 years ago, there was much more of an attempt to get people fired for their speech, to have students punished in various ways for their speech, and also outside of universities as well, to get private employees fired for their speech and the like. There's nothing radically new to any of this. In fact, there is actually something that is a pretty close precedent for it, which is the 1950s and the campaigns against communist speech, now coming from the other side. And even between the 50s and the last decade, there were certainly always attempts to restrict speech in various ways. But I have seen an uptick of that in universities, where the maybe as universities have shifted left, or maybe as the left has shifted itself, there's been more of a call for suppression of speech, that suppression of bad speech has become the left value, whereas it used to be pretty solidly, it was protection of speech that was the left value.
It is a pendulum that swings. How do you explain
I don't
that?
like the model of pendulum, because a pendulum doesn't just swing. It swings a constant amount back and forth at a constant period.
Sure, it's predictable.
That's the nature of the pendulum. It's true things move back and forth, but they hardly ever end up exactly where they started. And the worry is that even if there's some correction, the end result is going to be a position which is much less speech protective than before. Interestingly, the October 7th attacks on Israel provide an interesting opportunity to either create, I think, a broader coalition to protect speech on campuses, or a broader coalition to restrict it. I think what happened was that the history of the 1950s, and in some measure of the 1960s, taught the left that they are particularly vulnerable to speech restrictions, and that they need to protect speech so that kind of radical causes of the left, and even centrist causes of the left, are properly protected. And then what happened was, especially at universities, I'm inferring this, I can't prove that this is what was going through in people's heads, and some of it may in fact be subconscious, but I think it fits what I understand of human nature. What happened is that as the left got pretty solid control of universities, and as the lessons of the 50s and 60s were forgotten or never learned by new generations, the sense was, well, look, our speech, we don't even have to worry about, because everybody agrees at the university that our speech is good speech, so it's not going to be punished. We need to punish the bad speech from the right. And now that with October 7th attacks, there have been calls for suppressing speech that is seen as left speech, let's say pro-Palestinian, even pro-Hamas. By the way, I should say, I support Israel. I think the Hamas attacks were mass murder, completely unjustified. But I do think that even advocacy of Hamas ought to be protected by free speech and academic freedom principles. And it looks like some on the left may be relearning those principles and saying, maybe we shouldn't try to go after academic freedom as much as we used to. Maybe we shouldn't try to empower the government to have more restrictions on speech. So my hope is there's going to be a new coalition of kind of the newly free speech awakened or reawakened left, and moderates and conservatives who support speech. My worry is what's going to happen is some conservatives and some moderates will say, no. Now we see why it's really important to restrict speech. And many on the left will say, well, yes, it's true. Maybe it's not pro-Palestinian speech that should be restricted, but there's plenty of other speech that ought to be restricted. And there might be a new coalition for speech suppression. That's my worry.
That is a concern. I mean, it seems to me that whether it's the 50s, 60s, or today, and I guess everybody should agree with this in principle, that the idea of free speech should not know ideology. I mean, there shouldn't be this view that, well, it's our speech, therefore it should be protected, but your speech is violence. The opposing point of view is violence. Can words, this sounds so esoteric, can words be violence? What do you think?
Yeah, there's a great line that I have in my casebook, my First Amendment textbook that I wrote up, and it's words are bullets. The full line is words are bullets, and communists use them, know this and use them so. So this was a line from, I believe, the 1960s. I want to say it was the Louisiana legislature. That was a classic example of this attempt to suppress speech by recasting it as conduct, and in fact as violent conduct. But it was done there. It was done by the right.
Yeah. So
again, it's
the idea of
nature.
words as violent. That's not something
Right.
that the left invented.
It's not an exclusive province of the left or the right, or anybody else. It's human nature to want to suppress speech that you disapprove of. And even if in principle you agree with free speech, it's human nature to try to find dodges. Oh, that's not speech, it's conduct. That's not speech, it's violence.
Yeah.
And one of the things that makes it particularly dangerous is precisely because it is human nature, precisely because it's not some weird pathology that if only exposed, it would just vanish. It's something that has to be constantly fought, like many unpleasant features of human nature.
What
Right.
kind
And then
of
people think that as long as you have enough people on your side to give you the slimmest of majorities, then you can just do whatever you want and trot all over the other side. That's the danger.
Right. But I think what's worse is I don't think that's how people actually conceptualize it. I think they look, instead of seeing the slim majority, they see what to them looks like the almost unanimous view of people who matter, the right sorts of people, my
Right.
kind of people. They're the ones that you focus on, the enlightened people. And so you think that that's so, especially since people often travel in very narrow circles. So at the university, something that may be, in fact, a dominant view throughout society may be a small minority view at the university. And even if there are people who hold it, they realize that it's a small minority view, so they stay quiet about it. So the only people who talk are the ones who are in the majority of the university, and outlooks that's almost unanimous in the university. So it feels to many people, and again, I think this is a common thing on the right as well as the left and the center and everywhere else, is that it's to certain things, it's like there's no room for reasoned debate, of course, because your position is obviously the only right one. Like anybody who is against you must be a horrible person who's also planning all sorts of evil things.
Yeah, well, I've been on the receiving end of that kind of sentiment. That's for sure. Go ahead, Sonny. I'm sorry I keep cutting you off.
Yeah, no, I'm just wondering, in your experience in the classroom on universities, how have you seen the culture change over the years with the students' attitudes towards the First Amendment? Have you seen more students now? And like you were just talking about with the attacks on Israel, we saw on the news and in a lot of places there being a lot of protests in support of Palestine, and things just getting really dicey on campuses. So how have you seen the culture change on campuses over the last few years?
Well, that's not to me an example of the culture changing much, because that's just something we've seen from the 60s on to now, or students who get really ideologically worked up about something, protesting, and sometimes protesting in ways that are completely unprotected by the First Amendment or free speech principles. There's no First Amendment right to take over some school building. There may be a First Amendment right to have a rally in the Quad or to hand out leaflets, but there's no right to, for example, block entrances to buildings and the like. There's no right to tear down other people's leaflets. But the protest, the pure protest behavior is something that's pretty familiar. What I have seen before the October 7th events is this sense that students are entitled to be protected, entitled to be safe, not just from violence or threats of violence. All of us should be safe from that. But they're entitled to be safe from speech that they find offensive, or that they find kind of insulting to their identities, or otherwise that makes them feel unwelcome. And it's true that there is some such speech, but I think it used to be the sense was, look, if you don't like it, you should disagree with it. You should maybe muster broad support against it. That is to say, to controvert it. But now I think increasingly the sense is, oh no, it should just be prohibited. It should be prohibited on the part of faculty. It should be prohibited on the part of fellow students. No, I don't want to overstate the degree to which this has changed. I think there's been some element of that as well. And I'm always hesitant to talk about trends, because in order to say, well, there's much more of something now than before, you need to know just how much of it there is now and how much there was before. And it's pretty hard to measure even what's happening now, much less what was happening before, because most of us, as I mentioned, travel in pretty narrow circles. So we pay attention to certain things, and we don't pay attention to other things. Among other things, the advent of social media and of various other kinds of alternative media have made it possible to see things that perhaps before would not have been seen. So maybe there were restrictions on speech that are that were present 30 years ago, but just never made the news. And now there's so much more news of that sort out there.
Right.
This having
Yeah.
been said, people I trust at the Foundation for Individual Rights and Expression report that, as best they can tell, for example, when it comes to firings of faculty members, there's much more now than there was several years ago, and certainly than there was a decade or two ago.
I want to talk about that, them again, the Foundation for Individual Rights and Expression, FIRE. They're the ones who are representing you, or the lawyers from FIRE are representing you in this case, along with your co-plaintiffs, which are Rumble, which is the free speech video platform. Again, I mentioned that Rumble is a client, and also a social media network that they own. Locals is also a co-plaintiff. And Letitia James, the Attorney General of the state of New York, is the defendant, and she's the one who's charged with enforcing and defending the laws of the state of New York. That's why she's sued in her official capacity. What have you seen, and as you look at the AG of New York and this law passed by the New York legislature, what do you see out of the White House with Joe Biden and the people that he's got working for him in the White House? And Sonny mentioned that this is before Biden was president, but Hunter's laptop and how that was suppressed by social media. But we now know that after Biden became president, that the White House put pressure on these social media channels, Facebook, Twitter, and the like, YouTube, to remove content and suspend accounts and actually ban accounts that were engaged in speech that the White House did not like. We now find that that is extended to Amazon, and the White House putting pressure on Amazon to suppress books that expressed views largely about vaccines that they didn't like. So we heard a lot of times when we were complaining about the Hunter laptop suppression, oh, Twitter is a private, Facebook is a private company, they can do whatever they want. But when it's the White House instructing, and not asking, but instructing these private companies on suppressing speech, doesn't that change the game? I mean, what do you see, and how do you regard the Biden White House as it relates to its stance toward the First Amendment?
Well, first, the Supreme Court is going to be hearing this very issue next month in a case called Murthy v. Missouri. That case used to be called Missouri v. Biden, and many of your listeners might be familiar with it under that name. And there, the challenger, the plaintiffs said, look, the federal government has been doing two kinds of things. First, it has been coercing social media platforms to restrict certain kinds of speech. And the Federal Court of Appeals there, the Fifth Circuit, agreed in considerable measure with those claims. And then plaintiffs also said, even if they weren't coercing that, they were encouraging the platforms, systematically encouraging the platforms to restrict speech. And the Fifth Circuit also agreed with that and said that even that kind of encouragement, at least if systematic enough, could be unconstitutional, even in the absence of a showing of coercion. So that's what I think makes this a really complicated case. If there really is coercion, if the government is saying, look, remove this speech on your platform or else, or remove these books from your bookstore or else, that is pretty clearly unconstitutional. The debate as to that facet of the case is really whether there was enough coercion or whether it wasn't actually coercion, but just encouragement. But the second part, that's where the really interesting and complicated legal question is. Is it a First Amendment violation when the government merely encourages platforms to remove things? And again, it may be that it was doing more than encourage them, but even if the Fifth Circuit said, at least as to certain kinds of allegations, all that can be shown is encouragement, not coercion. And, that's complicated. So let's say, for example, somebody at the CIA calls up the New York Times and says, I understand you're about to run an op-ed about one of our operations. And let me tell you, I totally understand there's nothing we can do through the law to stop you from doing that. You have your First Amendment right to do this. But let me just tell you, if you run this op-ed, that's going to completely destroy our operation, maybe endanger our agents' lives, or in any event, just keep it from working. Your call, but we're hoping you'll do the civic-minded thing. I think we'd say that's not unconstitutional. It's encouragement that New York Times not speak, or maybe even not run somebody else's speech if this is an op-ed. But it's an acceptable kind of request, and it doesn't even require national security. Just to give another example, let's say that a government official from the CDC calls up the New York Times and says, I understand you're going to run this op-ed, but it's nonsense. It's just wrong for the following reasons. Or even if it's not technically wrong, it's highly misleading. Why would you want to run something that's so misleading? I assume you wouldn't, actually. I assume that now that you know that it's probably not accurate, it'll be good for you and good for the public and good for your readers for you not to run it. After all, people trust you to publish correct things and not incorrect things. Again, I don't think there's anything particularly wrong about that. So the question is there a First Amendment problem setting aside coercion? Let's assume that there's no threat. Let's assume there's only encouragement. Is there a First Amendment problem with that kind of encouragement? Maybe the answer is no. But even if there is, how do you draw the line between the permissible sort of encouragement? Look, you just don't want to run this op-ed because it's bad for national security, or it's just wrong, and the impermissible kind of encouragement. I'm not saying the line can't be drawn, and the Fifth Circuit tried to do it, and perhaps the Supreme Court will agree, and maybe it should agree. But that's what makes it a complicated question, I think.
Yeah, but you see some of these examples, these emails that came out in the Twitter files, and what we see now that the House Committee on Oversight has released about, or whether it was Judiciary, maybe released the what are called the Amazon files now, where you have emails from White House staffers ranting and raving at the social media people, demanding to know, why hasn't this post been removed? Why hasn't this account been suspended? Why are these books showing up on word searches when you do keyword search vaccine? Why is this book even available? That's the White House treating the social media people like they are employees at the White House.
Well,
that's not
yeah.
gentle asking, like, hey, would you consider not doing this?
Maybe. I think it's complicated. So you're suggesting, it sounds like this is like that's not just encouragement, it's coercion.
Yes.
Maybe. Part of the problem is it's not like Amazon or Twitter or Facebook are kind of small-time operators that, oh my God, how can we deal with the might of the federal government? They're pretty powerful themselves, and they know how to resist requests that they think are inappropriate. So it's hard to know how they would react to a particular email from a White House staffer. White House staffers are a dime a dozen. Maybe they'll say,
White House staffers.
Pardon?
I said, take that, White House staffers.
Right. Maybe they'll say, we've got a lot of regulatory requests to the government. We want to get this kind of waiver of this and that, or we're being investigated for antitrust violations and we need to stay on the government's good side. So we better go along with it, maybe. Or maybe in some of these situations, they say, well, all right, we appreciate it. We don't want to sell books that are misleading. So we're not being coerced here. We're just being persuaded. It's an interesting and complicated question. One way of thinking about it is if you run a bookstore, you actually probably, a normal bookstore, where you have to carefully select which books are on the shelves. You probably don't want to have books on the shelves that are false or misleading, or just otherwise kind of convey information, medical information that may actually harm your customers. Your customers may be trusting you to pick and choose which are the really good books on medicine and which are the foolish quack books on medicine. Now, maybe Amazon is different, because maybe we expect Amazon to have everything, because they can have everything. An ordinary bookstore can't have everything, has only limited shelf space, but Amazon can have basically everything. Maybe because we expect that, Amazon shouldn't be in a position to pick and choose, or at the very least, that wouldn't be the norm. So therefore, when people ask it to remove things, there may be more of a coercive pressure. But again, what makes it complicated is that in many situations, alerting a publisher or alerting a bookstore that the books that they are publishing or carrying are actually quack books, that spread misinformation about medicine, it's actually, many publishers might find that pretty useful.
Yeah, I mean, it's a tricky question. It seems ominous that the White House is flagging these things, saying, these are the ones we want removed. But, there is no First Amendment right to have your book sold.
Right. So the question is then whether there's a First Amendment right not to have the bookstores coerced by the government. The answer is yes. There's actually a case about that involving bookstores 60 years ago, Bantam Books v. Sullivan, where a Rhode Island government commission tried to pressure bookstores through pretty clear threats of prosecution to remove books that the commission thought were obscene. And they're not hardcore porn. They were just books that they thought were kind of contrary to their sense of morality. And the court said, look, if you've got that kind of coercion, that does violate the First Amendment. The bookstores may have been free to remove the books from the shelves themselves, but that doesn't mean the government can try to coerce them into that. So that is a First Amendment violation. Again, the really unsettled questions are, first of all, what exactly counts as coercion? And second, what if you don't have coercion? What if you have just this kind of systemic encouragement or requests, but kind of on a systematized scale to remove certain books? Is that independently a First Amendment violation? And again, that's something the Supreme Court's going to have to decide probably by late June of this year.
All of it is very fascinating, and lots of different layers to every single argument. Professor Eugene Volokh from the UCLA School of Law, thank you very much. We really appreciate your time. And again, the reason we were talking to you today was the immediate reason, fascinating though it was about other topics, is the case that you have brought as the lead plaintiff, along with Rumble and Locals, against the state of New York and their Attorney General Letitia James regarding their law that requires places like blogs like yours, the Volokh conspiracy, to police the speech and find avenues for folks to complain about the comments that they find. So we really, really appreciate your time, Professor. Let me ask one last thing: has UCLA been generally supportive of your work? I mean, you're out here kind of as a pioneer, pushing the envelope. Have they been okay with everything you've done?
I've had my differences with them, but on balance, they've been pretty good.
That's good. Good to hear. Good to hear. Well, we thank you very much for your time and your input and your insight. It is invaluable and fascinating, and I think that this will be a popular episode of ours. And we appreciate the listeners' time, because this has been the Line Drive Podcast.